Excuse me, Ms. Riley. Once we post the dates on the chat, are we excused?
I believe that's how the judge handled it before, right? You put the cause number, the name, and the reset date
Yes, ma'am.
on the chat. Yes,
Yes.
I believe judge would allow y'all to leave at that point, as long as it's
Thank
posted in there. And y'all have confirmed it with the DA.
Yes, sir.
And Ms. Riley, can I talk to my client?
Well, after I get access to be able to do the breakout rooms, I certainly can put you there. What, who's your client?
Joseph Guzman, do you happen to have his case number? Because I don't have my, I drove over instead of
Yes,
doing it
hold
on
on.
Zoom.
Okay, hold on one second. Joseph Guzman, you said?
Yes, ma'am. It's burglary.
And are you Edward Bartolome?
I am.
Okay, his cause number is 18-02
-02.
-0043
Okay.
CRA.
0043 dash, hold it a minute.
Ms. Riley, you are the host again.
Thank you, Judge.
(18-CR-00483).
No, 18-02-0043
0043. Thank you.
CRA.
CRA. Thank you.
You're welcome, sir. Okay, let's see. Hold on one second. Mr. Garcia, Israel Garcia, I'm going to try and find you and put you in breakout room 5. So let me see if I can find your name on here.
How would I get to breakout room 5?
I'm going to invite you to it, and you're going to get a little pop-up window that says inviting you to it. And you click
Okay.
on that button, sir.
Thank you, ma'am.
You're welcome. I can't find your name on here. There you are. Okay. Okay, should have a little pop-up window coming up.
Miss Riley, if I could get Will Richmond whenever you can. I know you're busy.
Yes, hold on one second. I have to write down the names and then put y'all's names. So Will Richmond. All right, Joe Guzman and the Justice Center will be in breakout room 6.
Thank you.
Will Richmond, you want to go back to room 3 and I can put Adrian in there with you?
Sounds good. That'll be fine.
Thank you. Who else needs a breakout room, please?
I do with Bradley if he's available.
Your name and the person's name?
John Lamerson.
Okay. And you said Brad
Yes.
Thornton? Okay.
And when they're out, can I
do as well.
1 second. Bradley Thornton, can you go back to room 1 and I can put John Lamerson in there with you?
Yes, ma'am.
Thank you.
And Brad, before you go, can you check the chat?
Whenever Will is available again, I will need a breakout room with him. This is Ruben Flores.
Ruben Flores with who?
With Will.
Okay. He's in a room right now. I'm sorry. Somebody from the probation wanted something.
This is me, Lara Tristan. I
Lara.
wanted to talk to Mr. Lamerson, but he went in with Brad. So I guess when he comes out.
Okay, yes, just hit me up. I have like a long line and my rooms are like crazy. Like,
Right.
And
Brad,
I actually would like to talk with you if we can.
who are you talking to? Tony?
I'd like to speak with Laura
Okay, sure.
with probation.
Will Richmond?
Adriana Biggs is available.
So Adriana Biggs, you said?
Yeah, the
Laura?
3 of us, if we can do a breakout room,
Sure.
or I can speak with them
Let
separately.
me put you on 7, okay?
Whatever's easy.
Will Richmond, I don't show you going into room 3. Adrian's waiting on you.
Oh, okay. Oh, I didn't realize there was an invite.
No, you can just go back into it. You should be able to.
Oh, I
Let me
think
move you. Let me move you from 1, and I'll move you to another. But I need for you to go to 3. So don't accept the room 7. I'm going to put you in.
okay.
Riley.
Hold on. One moment, please. Let me get.
Yes, ma'am.
I need to get Adrian. Let me see if she's available, where she's at. Miss Biggs, can you go back to room 2?
Yeah, I just don't have I'd be happy to go back when the window pops up.
All right, I'm gonna put you on room 7 then.
Oh, you do that. I'll be happy.
Okay.
Yes, sir.
And Ms. Riley,
Yes,
what are our plea dates?
I posted those, and they are 6/23, 6/28, 7/26, 8/2, 8/4.
All right, Mr. Guzman, 6/28, I believe. That's Friday.
And the judge is gonna want you to put the cause number,
I will.
defendant's name, date in chat.
Thank you.
Who else needs a breakout room that I haven't got to yet?
I do.
Who's I do?
Yeah. Trala, Sean Keen Dawes.
Who do you need, sir?
Brad Thornton.
I think he's still in a room, so let's see. Hold on. I think he's still. Yeah, he's still in breakout room, so catch me when he gets out. Okay, and I'll hopefully get you in there soon.
Ms.
Who
Riley.
else? All right, so
Riley.
Roland Hernandez.
Yes, ma'am. I'm still trying to find where Megan Harkins is at on the docket. I don't see her. Do you know what the charges are to do an interview with her?
Megan Harkin or Megan Monk? I think it's Monk.
I think, well, I wasn't sure what it was. I just saw her name on the picture.
Let me see. He said to put her, it's Megan Monk, I believe.
Yes, ma'am.
Megan Monk, you have a civil case or a criminal case?
It's a civil case, ma'am.
Do you have a cause number on that offhand?
That's why I have a question.
Oh, hold on one sec. Yes, ma'am.
It's 17-07-07-0625-CVA.
Okay, hold on one second. Mr. Hernandez, yes?
I'm not sure we're supposed to do civil on the thing on the text share, what he wants.
Right, I
I
don't know.
thought that was
either.
criminal.
That's what I thought too. I'm not sure, sir.
Yeah,
Can we
they're
just-
not supposed to do civil.
I mean, we do have a civil division, but we don't do interviews for them. But I can check with Ms. Walters and see what she tells me.
Sure, okay.
And then the other one's going to be Rick Ramirez. He's going to need Jesus Flores in the breakout room to interview.
Jesus
Thank you.
Flores and who?
Rick Ramirez.
What's the first, it goes by the first name. If you can tell me that, what's the first name? It's Jesus Flores and who's the other person?
Yes.
Rick Ramirez.
Rick?
Yes, ma'am. The investigator for the trial. The other one.
Oh, okay. Sorry. TRLA, right?
Yes, ma'am.
Okay,
Thank you.
yes, sir.
And Lori, can I be put in a breakout room with the jail?
Who do you need, sir, in the jail?
Juan Samaniego.
Okay, so jail, can y'all get Juan Samaniego?
Yes,
present? Okay, I'm gonna go ahead and invite y'all to a room, and Jason Nitz wants to speak to him, so if y'all can go to breakout room 8, please.
Lori, can I get on that list as well to talk to Mark Olivan at the jail?
Mark Olivan,
Page 3. Yes.
okay. Sure, as soon as they get through, we can
Which
get you
room
in
was
there.
that?
8.
This is Tilden Schaefer for Joe Maldonado. I guess either getting a breakout room in line with Will or Bradley.
Hold on 1 second, please. And what was your name, sir? That was just speaking?
Tilden Schaefer, and I've got Joe Maldonado. It's
Joe Maldonado?
yes, ma'am.
Is he in jail or is he?
No, he's on bond and he's present.
He's okay. So he's present. You need to speak. You need to speak to him in a breakout room. You said.
No, with one of the ADAs who's available.
Okay.
Lamb, but he's not here today, so.
Let me see if anybody's available. Brad, can you go back to breakout room 1?
Sure.
And I'm going to put Tilden Schaefer in breakout room 1 with you. If I skip somebody, I'm sorry.
All right, Mr. Scheinthal.
Mr.
Cornell?
No. Who did you need, Judge?
Mr. Scheinthal, Alan Scheinthal, Pawnee versus Cornell Carriers.
I don't know where he went. I'm not sure where he's at, sir.
I have no show on that, Judge, for that case.
Well, but then he came back in. He took a while to unmute, he said.
I don't know where he went. I think he's gone, it looks like.
Okay, well, he may have figured out that Judge Ellison signed the order he's asking for
Okay.
back on the 20th of May, so I was just going to tell him he was free to go. Thurman versus Arwijo and 281 Tire Shop.
Nicholas Morales here for plaintiff, and that's our motion to withdraw.
Okay, and you have your service on Mr. Thurman?
Yes, Your Honor.
Okay, do you have your proposed order?
I do, Your Honor.
If you would post that to me in chat, I will sign it.
All right. Thank you, Your Honor.
Your Honor, we're back from the breakout room on our case with Mr. Garcia whenever you're ready. It's an agreement.
Okay, go ahead.
Ms. Phillips and Mr. Garcia. Mr. Garcia, I don't see him. Where did he go?
He's still in the breakout room?
I'm right here, Your Honor.
He is, okay.
Oh, there he is. I can quickly announce our agreement, Your Honor.
Go ahead.
All right. The parties have agreed that my client will be, Ms. Phillips will be temporary sole managing conservator, and Mr. Garcia will be temporary possessory conservator. The visitation with this child shall be every other Saturday, beginning this Saturday, June 26th, from 1 p.m. to 3 p.m., supervised by my client's grandparents, Martha Yanis and George Yanis, at either the Yanis home or another public location such as Burger King or McDonald's, something, or a park, something like that, according to their agreement.
All right, sir, is that
And
your
that
agreement? Mr. Garcia?
Yes, Your Honor.
Okay. All right, and how long do you need to get this typed up, Ms. Vickers?
Your Honor, if you could give me, I don't know, 3 or 4 weeks, I will get to it as quickly as I can. And I would also need to make sure I have Mr. Garcia's email address if he has one, and I can email it to him, possibly. So if you give me 3 or 4 weeks, then I can have a way to contact him.
Would a number be fine, ma'am?
You have a phone number, Mr. Garcia?
Yes, ma'am.
Okay, yes. What is that?
210 809
809
2027.
2027. Do you have a
Yes, ma'am.
mailing? Do you have a mailing address also in case I need to mail?
Yes, ma'am. 806 Crockett Street, Pleasanton, Texas.
What was the name of the street?
Crockett Street.
Crockett. All right. All right, Your Honor. Whatever date you want to
And
do.
what I would suggest is if you'll just look on the online calendar and pull a date when I'll be back here.
Okay. Going to that right now.
Back on Wednesday, that's too soon, right?
Yes, I'm gonna need
3 or 4 weeks.
I gotta have at least 3
July
weeks to get this
20th would be the next available when he'll be back.
Okay. July 20th?
Yes, ma'am. That's a jury docket call date, but
Yeah, I don't expect there to be a big problem. Okay, let me look at July 20th.
and the July 26th as well.
July 20th will work for my calendar. So we can make it July 20th. Will that be in person?
Yes.
Yes.
Okay.
All right, Mr. Garcia, Ms. Vickers is going to send you a proposed order on temporary orders, a proposed written order for me to sign. If you agree with her that that is what you have agreed to, and that she's written it up correctly, if you will just sign it, she can e-file that, and no one needs to be here on July the 20th. If the two of you are unable to come to an agreement, by that means that you don't think that she's written it up the way you understand it, and you can't get that worked out, then we'll have a hearing on July the 20th.
Yes, Your Honor.
Okay, all right. Then, Ms. Vickers, you're excused put 720 entry, and Mr. Garcia, I need you to hold on because you still have your criminal case.
Thank you, Your Honor. My client and I are going to leave the meeting. Thank you.
Thank you.
All right, give me just a moment.
Your Honor, I'm sorry I'm late. It was completely my fault. I forgot. I'm here at work.
Okay, what's your name?
Angel Hinojosa. Mr. Cabañas is my lawyer.
Okay. All right, what day did we get for Mr. Cabañas's cases that were supposed to plea?
I haven't. Sorry.
1 second, Judge.
Sir, your attorney should be here later, but he is in a federal court right now. So
yes.
I may ask you just to hold on until he shows up.
Okay.
Ms. Riley, when you get a chance, if you could make me the co-coordinator.
I'm sorry, Judge.
The
Yes, sir.
co-host. All right.
Who's
so
that? Who?
There you go.
No.
Ms. Riley, if we post it, may we be excused for the plea on the 28th?
Yes, I believe Judge says y'all can leave if you've posted it with the cause number, defendant's name, and the
Yes, ma'am.
the court date.
Thank you. I appreciate it. Thank you for your help.
You're welcome, sir.
Laurie, I'm sorry, what court dates do we have to choose from?
I just posted them to everyone. If for the pleas are 6/23, 6/28, 7/26, 8/2, and 8/4.
Okay, and I just posted, I wasn't sure who was here from the clerk's office, so I just posted the withdrawal order to everyone on the 281 tire shop case. So it's going to be James Thurman pro se.
Judge, I have an announcement on Cristobal Estrada, which I believe is page 2 of the criminal docket.
Okay, what's that?
It's 19/11/02/81. And the announcement, the reason that we were here was to check on the progress status of his competency. And I've been informed by District Attorney Lamb that he has now been moved to SASH, so SASH, the hospital. So the status that we were going to check on was to make sure that he had done that.
Okay, excellent.
And I had a motion and an order prepared for today, but that no longer needs to be signed since he's in SASH.
Okay. All right. So how long is he going to be there? When do we have a hearing set for when he's getting close to whatever his time is?
I don't have a date set, but if I could get a date, she doesn't have to tell me today. She can send me an email. I know today is a hectic day, but I'm okay with either way.
Okay, what's the time?
Oh, I would guess probably 60 days. I think that's usually a good time to check and see. He might be back earlier. If he is, then we can alter that date.
All right, if you'll just go and look for a date for either judge about
the
middle of August.
August 4th would work. That's one of the dates we have. I can give you some other dates if you like.
August 4th will work, yes, Your Honor. We can check at that point in time.
Or August 23rd.
Would that work better, Your Honor? August 23rd?
It's all the same to me.
Okay. August 23rd, if I could, Miss Riley.
Yes, if you'll post it, please.
Yes, ma'am, I will.
Your Honor.
Yes.
I'm here for Roman Alvarado. I have spoken with Brad, and we remain on docket. Just a trial case.
Okay.
He's on page 4, Your Honor.
I found him.
So may my client and I be dismissed?
Yes.
Thank you, Your Honor.
All right, Mr. Richardson, on your the civil ads.
Yes, Your Honor.
Okay, I just pulled the petition. Looking at it. All right, sir, do you want to have your client sworn in?
Yes, Your Honor.
Is she there present with you or is she on separately?
She's on separately, Judge, Vanessa Tiarina.
All right, Ms. Tiarina, if you'll unmute your phone.
Okay, I'm here.
All right, I'm going to ask you to start your video.
Okay.
All right, do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, go ahead, Mr. Richardson.
Thank you, Judge, if I may.
Hi, good morning, ma'am. Please state your name for the record.
Vanessa Tejerina.
And are you the mother of the child, Modesta Maria Tirina?
Yes.
And who is the father of that child?
Benjamin Hernandez.
And was there an underlying Attorney General's case under cause number 16010033 CVA?
Yes.
Okay. And did Mr. Hernandez execute a voluntary relinquishment of his parental rights?
Yes.
Now, with regards to the child, Modesta, Mr. Hernandez has never had any relationship with the child.
No, he hasn't.
He has never provided any type of support for the child.
No.
You're asserting to this court today that you are capable of providing both financial and medical support for your child on your own?
Yes.
And you are asking today that this court accept the relinquishment of Mr. Hernandez and terminate the parent-child relationship between Benjamin Hernandez III and the child Modesta Maria Tiarina.
Yes.
And you're asserting to this court that you believe that this is in the best interest of your daughter.
Yes.
That's it, just.
And I see there was a adjudication of paternity from last year.
Yes, Your Honor.
And do you have your proposed order, sir?
Judge, I was having some issues getting it e-filed, but I do have a copy here that I can share in the chat if the court wants me to do that as well.
Yes, if you have it in a PDF format, if you'll just post it in chat.
Okay, let me see. And I do that through the screen share, correct?
No, if you'll just go to a chat and where it says
Oh, I see it.
click on me, and then you can hit file and post that.
Perfect. Let me see. Okay, Judge, that's just been posted in the chat.
Give me a chance to look this over.
Were you needing somebody from the jail, Judge?
Ms. Riley may, she's doing the breakout rooms.
Yeah, we needed Mark Oliva.
Yes, ma'am.
Ms. Riley, from TRLA, can I still get, do you have a room available?
Yes, who do you need? I'm sorry.
Jesus Flores.
Is he in jail or is he?
No, he's
I'm
on,
right here,
on
ma'am.
Zoom.
Okay, I'm sorry.
Thank you, ma'am.
Yes. Jose Flores, you said?
Jesus.
Flores, though, right?
Yes, ma'am.
Okay,
Yes.
sure. Let me get y'all in room 10.
Okay, thank you.
Ms. Riley, Ryan Boyer, could I get with Adriana Biggs?
One moment, please. What was your name?
Ryan Boyer.
John 6.
So give me just a second, Mr. Richardson.
Take your time, Judge.
And Megan Harkins, I'm gonna put you in number 11 with the jail. Anybody else need a breakout room that I haven't placed in a room yet?
Yes, ma'am. John Lamberson, if I could meet with Will Richmond.
Will, okay.
As well, this is Ruben Flores.
One moment, please, sir. Let me get them in the room real quick. Number 14 for Lamerson and Richmond. I'm sorry, Mr. Flores, you said Ruben Flores? Is that correct?
Okay. Who is online from the district clerk's office?
I thought Chris was.
Yes, sir. It's me.
Okay, all right.
Need Will as well, but I'll stay on standby.
Okay, I just posted to the district clerk and to Mr. Richardson a copy of the order. The only change I made was I made it so that it's without prejudice to any child support due through today. So any amount he already owes, I'm not letting him off the hook on that, but I will find it's in the best interest. I don't like to do these where you create a half an orphan, but given that the Attorney General case has been on file for 5 years and they have not been able to get it to a final judgment yet, it's obvious that the father has not had contact with the child. All right, you are released, sir. Have a good day.
Thank you, Judge.
Ruben Flores, did you need a breakout room with somebody?
Okay. Did Eugene Hernandez ever appear?
Am I able to go, Your Honor?
Yes, ma'am. You're released.
Okay, thank you.
All right. Did Eugene Hernandez ever appear in the Ovation Services case?
Hello.
Yes.
I'm here. I'm finally able to get on. I had to come down here and let the deputies help me get on.
Okay, who is I?
Eugene Hernandez.
Right, is Mr. Haley here?
I am, Your Honor. I am.
All right, I'm gonna ask you and Mr. Hernandez to meet in a breakout room. And who just logged on with a 210 area code phone number?
That is me, Your Honor, Sarah Louise Tijerina.
On page 9, Judge, and I think she needs to be interviewed.
Judge, on Ms. Tijerina, when she was asked she wanted a court-appointed attorney at the jail, she advised she was going to get her own counsel. So we need to interview her if she still needs it.
Okay, I had her as a no-show. I'll mark you present, ma'am.
Thank you, Your Honor.
And ask you to get with Mr. Hernandez from the Texas Rural Legal Aid.
Okay, thank you, Your Honor.
I'll put you in a breakout room, ma'am.
Judge, if you have time on that other one, Nasus.
Yeah, I'm not going to worry with that right now. He's got an attorney. I mean, we got to get it taken care of.
Yeah, actually the new charges are the ones that you appointed to trial. The other ones were Adrian's.
Okay, well, I'm going to change that so that he has the same attorney with everyone. So we'll leave it with Mr. Perez.
Okay, sir.
All right, Mr. Hilly, are you ready for a breakout room with Eugene Hernandez?
Actually, Your Honor, I would like to just go forward because my instructions are not to agree to anything, but to ask for judgment. So there's no point really to ask. We're not going to agree to any kind of reset.
All right, sir. Well, I'll just call that case when it comes up. All right, Hoffman versus Elwood Staffing. Would the attorneys post to me in chat a copy of the whatever I need to look at, your motions?
Yeah, Judge, this is the attorney for the respondent, the plaintiff in the case. We did file a response to their motion for summary judgment, so I will post that in the chat.
Thank you.
And Judge, just briefly on William Dillard, first person on the first page. This is a status hearing. Bradley is going to look in to see where he is on the list for the commitment. And I think we need a short reset with 726. 726 looks like it's a little bit far away. Can I send him on the jury docket call just for the follow-up, the status on that?
Okay, who is this for?
William Dillard, first page.
It's Dustin Wilmer.
Oh, sorry, Dustin Wilmer, sorry.
Okay, that sounds better. Okay, this is Judge Ellison's docket.
What date was that? The 6/28?
Yeah, 6/28 would probably be, well.
That is Judge Ellison's docket.
Okay, but is that a docket call?
No, sir, it is not. It's a regular pretrial.
I know that he doesn't want a lot of stuff cluttering up docket calls. So if you'll just post 6/28 in chat, that'll be fine, sir.
Well, I'm fine. And but there's nothing between 6/28 and 7/14. Is there anything in between there that we can just put them on there for the status?
All right, just work that out with Ms. Riley. I don't want it on Judge Ellison's docket call or jury selection unless he okays it.
Okay, so 6/28 would be.
Yes, it's good. That's a good date.
Okay, and on the Hoffman case, was something being posted to me in chat?
Judge,
Yes, Your Honor.
I'm waiting on it. I'm getting that from my assistant right now. We had filed it, but I'm waiting on her to send that to me so I can post it.
Let me see if I can pull it up. It's been kind of hit or miss this morning with the clerk's records.
Lori, this is Will Richmond. I think Mr. Flores wanted to chat with me, so I'm available.
Just a proposed order for that case is in the coordinator queue.
Judge Wilson, this is Travis Odom for Elwood Staffing. I'm showing that I was able to upload the motion and the reply. I just want to be sure you see those.
All right, thank you. All right, give me a moment to read these.
Judge, my assistant said that she's trying to send me the response, but it's too large.
Okay, I've got it from my
Okay.
counsel. Thank you.
Thank you.
Jesus.
Ms. Riley?
I just saw your,
Okay, thank you.
I think she's with the jail. He's in jail, correct?
Yes,
Okay, let me join you in there.
thank you so much.
It's, give me room 11, okay?
All right, and I'm sorry, the reply is the reply to the defendant's, the plaintiff's response. Don't know that I have a copy of the plaintiff's response.
Did you need me to send you the response as well, Judge? I could probably do that.
Yeah, Judge, I'm sorry. I thought that's what you were talking about that you had already.
I should have realized there were 3 pleadings.
Judge, it shows that it was successfully sent on my end. The plaintiff's response, that is.
All right, here it comes.
Judge,
Yes.
I'm gonna be right back real quick.
Go ahead.
Alrighty. And Judge, on the Megan Monk, I think you asked for the investigator to interview her, but they weren't sure they were allowed to since it was a civil case. They were going to check with, I think, with Miss Walters.
Okay, who said it was a civil case?
That's what they said.
It is, Judge.
I think she has a civil case, but it's not set. It wasn't set today.
Okay.
It actually is. I uploaded
Is
the reset order to Judge on her case.
Hey, who's on the other side?
It's Chad Marler and the Attorney General's office. That's what I have.
And they aren't here?
No, I didn't have it on the docket. I didn't know it was reset. I'm not sure.
May I speak?
Yes.
I have the paper that was signed by Judge Ellison. It was reset for today, and he does have an attorney, Tess House, and a gentleman named Mr. Wilson was there representing him. He signed it, I signed it, and Judge Ellison signed it for it to be reset today, and I have that paper in my possession.
Your Honor,
Yes.
this is Mr. Martin.
I'm sorry, I muted you by error. Smaller?
Can you hear me now, Judge?
Yes.
Okay, I have the same paperwork she has. We checked previously and we were not on the docket. So I was in contact with my attorney last week and she called the courthouse and confirmed that we were not on the docket. We actually went up there this morning just to make sure.
Okay, sir. Your name is Paul Marler?
Chad Marler.
Chad.
Paulina
Marler?
is my wife. I'm on her phone.
Okay. All right. Who's your attorney?
Tess House.
Okay. What does Ms. House's office say?
She said that we did not have a hearing today.
Okay. Well, all I know is that it's not on the docket. Ms. Monk, do you have any motions or things that need to be heard?
Yes, Your Honor. This was supposed to be the final hearing on all pending requests for me to have visitation with my daughter on the weekends.
Okay. All right.
And
Mr. Mahler,
his
okay. Mr. Mahler, I'm going to ask you to contact your attorney's office. And who has the reset form? Who sent me a reset form?
I have a copy of it.
I did, Judge. I uploaded it to you in chat.
Okay, at what time?
About 10 a.m. If you need me to, I can.
No, I
resend it.
found it.
Okay.
Now it has a criminal case number and a civil case number?
No, Your Honor, they were out of the civil sheets. So Judge Ellison asked us to do it on the criminal sheet to reset it, and his attorney did sign it. They knew we had a hearing today.
All right, Mr. Marler, you need to get in touch with Ms. House and see what's going on. So she needs to report to the court.
Yeah, okay. Your Honor.
Yes, sir.
Okay, once I get in contact with her and let her know she needs to get contact with the court, do I need to get back on the Zoom hearing, or what would you like?
Okay.
Yes, and then we'll
Okay.
wait until we hear from the court, hears from her.
Okay, we will do that.
All right, Hoffman versus Schlumberger. Let me get a, oh wait, Michelle, are you back? All right, do the attorneys want a record in the Hoffman case?
No, Your Honor, I don't think we need a record.
No, Your Honor, we don't.
All right, go ahead, Mr. Odom.
Thank you, Your Honor. Travis Odom for Elwood Staffing. As you know, this case involves a single claim of workers' compensation retaliation under Chapter 451 of the Labor Code. Elwood Staffing is, as its name suggests, a staffing company, and the facts of this case involve they're placing the plaintiff, Mr. Hoffman, at a job for Schlumberger, first in Angleton and then later in Jordanton. Plaintiff has pled that the defendants fired plaintiff in retaliation for filing his workers' comp claim. At his deposition, though, plaintiff admitted that he does not believe he was fired for making a workers' comp claim. The question was, is it your belief you were fired, whatever the word you want to use, from Elwood because you filed a workers' comp claim? Answer, no. So plaintiff in his summary judgment response tries to shift the conversation away from termination and instead says, well, the retaliatory acts were now two separate instances of not bringing jobs with Schlumberger to the plaintiff's attention. Elwood has brought forth, legitimate, non-discriminatory, non-retaliatory reasons why those jobs were not brought to the plaintiff's attention. And we contend that the plaintiff has brought forth no evidence that suffices to challenge those legitimate, non-discriminatory reasons. And so summary judgment is warranted. I'll briefly go through the facts. I'll try to truncate this a little bit. The plaintiff started working with Elwood in November 2016. He was hired as an operator working for Schlumberger in Angleton. February of 2017, he got hurt. He went out for 3 months, came back, and Elwood told him that job you were on is no longer available, but there's another one in Jordanton. So he goes to work for Schlumberger at a different facility in Jordanton, Texas. That was in May of 2017. September 4th of 2017 is when he injured his back. And that's the injury for which he filed his workers' compensation claim in this case. 2 days later, on the 6th, he notifies Elwood of the injury. Elwood immediately starts the workers' compensation process. Mr. Hoffman was out of work. He had surgery in September and he was off work until January the 8th, 2018. On January the 8th, he emailed his contact at Elwood, whose name was Nikki LaFrance, emailed Miss LaFrance his release, and she responded immediately that Elwood didn't have anything for him at that time. Mid-February 2018, February the 13th, Mr. Hoffman emailed Miss LaFrance and says, why was I terminated? And she immediately responds, you were not terminated by Elwood. You're still an Elwood employee and eligible for assignments. Your Schlumberger assignment just ended because they had to fill the position while you were out on leave. Then March 30th, Elwood sends Mr. Hoffman an email offering him a position as a cement operator. And he never did respond to that email and never did really respond to Elwood or seek employment with them after that date. My understanding is that he was already working for someone else at that time. He was administratively terminated because he did not check back in with Elwood for more than 30 days. And so that was the termination in our mind. Now, the prima facie case that the plaintiff makes in his summary judgment response, again, is he tries to shift the focus away from the termination and says, well, no, the retaliatory acts were that A, when Mr. Hoffman was released to work in January, he wasn't invited to a job fair. And B, that in February, about a month later, there was a job opening for Schlumberger in Jordanton to which he was not assigned by Elwood. Now, Elwood has legitimate non-discriminatory reasons why both of those things happen. First one, as to the job fair in January, there's plain testimony in the affidavit of Ms. LaFrance that when Mr. Hoffman was released to return to work, Elwood did not have any request from Schlumberger to fill any jobs for which Mr. Hoffman would be eligible. And so that's the reason that he wasn't notified about any openings is that Elwood had not been asked to fill any, and that's uncontroverted. In February, there was a job in Jordanton for an operator that came up, but Mr. Hoffman was not eligible for that job because Schlumberger had implemented a rule that said any employee had to live within 50 miles of the work site. And it's undisputed that Mr. Hoffman did not live within 50 miles of Jordanton. So he was not contacted about that job. And those are the two retaliatory acts that plaintiff alleges. Now, the plaintiff's job then at that point is to try to bring forth evidence that the legitimate reasons given by Elwood are either false or pretextual. But the only evidence that Mr. Hoffman's able to bring forth is A, that according to him, there was this job fair for Schlumberger, but he's not able to show any evidence that there were jobs for which he would have been eligible or that they were jobs that Elwood had been asked to staff. There may have been jobs available directly through Schlumberger. Ms. LaFrance testifies to that in her affidavit, that she has no knowledge of whether Schlumberger had jobs. All she knows is whether Elwood was asked to staff those jobs. And the uncontroverted evidence is that Elwood was not. As for the 50-mile radius that kept Mr. Hoffman from eligibility for the job in February, again, Elwood only knows of the requirement that Schlumberger set forth, the residency requirement within 50 miles. Elwood has not testified to any reason for that requirement and doesn't know the reason. Schlumberger knows that reason. But there's been no evidence put before the court that the 50-mile requirement was because of any particular reason. Nevertheless, the plaintiff's response states several times that the 50-mile residency requirement is pretextual and false because the plaintiff was never paid for housing during the time he worked at Schlumberger. So the plaintiff is assuming that that's the reason for the 50-mile requirement, but there's no evidence before the court that that's the case. And so the plaintiff has not brought forth evidence rebutting Elwood's legitimate reasons why those two particular opportunities were never brought to Mr. Hoffman. And as those are the only retaliatory incidents on which they're basing their claim at this point, summary judgment is appropriate.
May I respond?
Yes, sir.
Judge, first of all, if you look at our response, you'll see that we have provided not just more than a scintilla, but a very substantial amount of evidence from the deposition of Mr. Hoffman that does controvert the affidavit of Ms. LaFrance. Opposing counsel spoke about the fact that he can't show that there was actually any jobs for which he would have been qualified or that he was that would be available to him offered at that job fair, but he testified in his deposition that there were jobs for operators being posted at the job fair that occurred 2 days after he was told that there was no job available to him.
Okay, but what's the relationship between the job fair and the?
Yeah, let me back up a little bit and explain why that's important. When Mr. Hoffman comes off his medical leave, he contacts Ms. LaFrance at Elwood Staffing and says, "I've now been released to work." After he tells her this, she then informs him that, "Sorry, but we don't have your position anymore. It's been filled by other people. Okay. Couple of days later, there's a job fair for operators, which is what Mr. Hoffman was. He was an operator for his same position for Elwood Staffing at the same location, at the Schlumberger location where he was working before.
Okay, and I guess my question is, did Elwood run the job fair or did Schlumberger?
You know, Judge, I know that it was for the Schlumberger location, but I'm not sure if it was Elwood or Schlumberger that actually ran the job fair. I know it was for that the same location where he was working before that.
Go ahead, sir.
So first of all, so a lot of the evidence in this case, and just like any cases like this, whenever you have a retaliation claim, the evidence is usually circumstantial. You've got a situation where he gets off medical leave after being on comp for 3 months, and he's told, we no longer have your job available. It's been filled by somebody else. That's in the affidavit of Ms. LaFrance that's attached to the motion for summary judgment. That in of itself creates a fact issue in this case as to whether or not retaliation in fact occurred as a result of filing a workers' comp claim. He files a claim, he comes back and he's told, sorry, we don't have your job anymore. If anything, there's definitely a fact issue here, and this case needs to go in front of a jury and let the jury decide what the actual motivation was of Elwood Staffing.
All right. Anything else, sir?
Nothing further.
All right. Anything else from the defendant? Mr. Odom? Did he drop off?
It looks like it froze up.
All right, let's give him a moment to come back.
Okay.
Judge, while he's coming back, may I make a brief announcement?
Yes.
Judge, on my client on page 3, Mark Olivon, that will be a plea. I would like to leave the Zoom, run to the jail, and then come back just to get him to sign that plea paperwork.
Certainly.
Okay, thank you. I'll be back when I can.
And Your Honor, I think pending Ms. Biggs, we have a resolution, at least a recommended disposition on Roland Lugo's MTR.
Okay, let me see. Is that Mr. Odom back?
Yes, Your Honor. I apologize. My internet cut out.
Mr. Judge, I do have one more thing to add now that Mr. Odom is back with us.
Okay.
In Mr. Hoffman's deposition transcript, which is attached to our response to our motion, he does say that it was Ms. LaFrance that he saw that had put up a job fair for the Jordantown location. So he did believe it was Elwood that had in fact posted that job fair.
Okay, and what page of his deposition is that?
Yeah, if you'll look at page 161, that's where he talks about, if you go down to 161, line 16, it starts there.
All right.
Yeah.
Mr. Odom?
Yes, Your Honor. I would say that in response to that, Mr. Hoffman still didn't testify that it was an Elwood job fair, just that he received notice of it through Ms. LaFrance. I think that these facts are not before the court. I think it was a Schlumberger job fair, but that's not, that fact is not before the court. When asked whether he knew why Ms. LaFrance didn't bring the job fair to his attention, he said that he does not know. That's on page 162, right next to the quote that council just pointed you to. I would also like to point out that even if there were positions for operators at this job fair, which Mr. Hoffman thinks there were, he represents in his response that there are operator positions for which he is not qualified, because he says he wasn't qualified to be a cement operator, which is the job that was offered to him through Elwood on March 30th of 2018. So without some more detail about what types of operator positions there are, then simply saying this job fair had operator positions at Schlumberger, that doesn't get him to the point of saying that there were positions for which he was qualified. And it certainly doesn't get him to the point of saying there were positions for which he was qualified that Elwood had been asked to staff. That's completely absent from the record.
Well, may I respond to that, Judge?
Yes, sir.
Just one last thing is that if we just look at the motion for summary judgment evidence that was filed by Elwood in this case, and we just look at the affidavit of Ms. LaFrance, we'll see that she states in her affidavit that when Mr. Hoffman returned, his job was no longer available. They had filled it. It doesn't matter really what happened after that, whether he would have been qualified for another job or not. The fact is they filled his position with somebody else and didn't have a job for him when he came back. That in of itself is, I think a jury could determine is retaliation.
May I respond?
Yes, sir.
So two things. One is that Ms. LaFrance says in her declaration, her affidavit, that the position at Schlumberger was filled because Schlumberger asked that it be filled. And so I'm not sure how that could be evidence of any retaliatory act by Elwood. And second of all, this is yet another argument that's not made by plaintiff in his response. The response says that the two retaliatory actions at issue were the failure to notify Mr. Hoffman of a job fair and the failure to offer him a February 2018 opportunity in Jordanton with Schlumberger Extreme. And there's never been an allegation until just now that the retaliatory act at issue in this case was filling Mr. Hoffman's job while he was out on leave, which, by the way, the company has the right to do. He was not entitled to FMLA protection, and that's a separate claim anyway.
All right. Okay, I won't comment on what I think Mr. Hoffman's chances at a trial on the merits are, but I've got to say that this strikes me that this is sort of case that the appellate court would probably conclude that there's some sort of fact issue working in there, and I'll deny the motion for summary judgment. So,
Judge, we have an order we filed this morning, but I can upload and send you one on the chat.
Post that in chat to Mr. Odom and myself. I'd appreciate it.
Okay, will do. Yeah, right now.
All right, and Ms. House?
Yes, Judge.
Okay, I don't know if you received a copy or you have your copy of a reset form that Judge Ellison had signed.
I did not receive that, Judge. My associate attorney at the time, Greg Wilson, was on this case, and he is no longer with the firm as of last week. I did do my due diligence and contact the court last week to see if this was set. It was my understanding that nothing had been set, and we were in the processing of having this set. So,
okay. All right. So are you ready to go forward then?
Well, no. I mean, no. I mean, it's set for a final trial on the merits, and the next setting that I'm requesting are temporary orders that apparently either need to be entered. the attorneys at the time, Lucinda Vickers and attorney Greg Wilson, entered into an agreement for temporary orders. They were never entered. And so the next setting is either to enter those orders or have temporary orders present. This deals with a child. It's a SAPSR mod, and I don't think it would be doing the child any justice to proceed with the final trial without temporary orders entered.
Okay, I'm going to ask you to get with Megan Monk in a breakout room and see if you can agree on a date for a final hearing.
Okay, and I have dates available. I can do that.
You had stuff, 2 weeks open up next month. I know.
Yes,
All
sir.
right, so Ms. Riley, if you would place him in a breakout room, I'd appreciate it. Ms. Monk, you should get an invitation in just a moment to a breakout room where you and Ms. House, the attorney for the other side, can discuss a date. I understand, I'm not sure what happened, Ms. Monk. It did not get down in the court administrators records that this case was set today. And I'm not going to make Ms. House just show up at the drop of a hat. I would extend you the same courtesy if your attorney, if you had one, it did not appear or was unaware, especially after having checked with the administrator's office. So I'm going to ask you to confer with her and see if the two of you can come to an agreement on a date to get whatever needs to be heard.
Yes, Your
And
Honor.
Judge, may I have Chad Marler join us as well? Mr. Marler is my client.
Yes, that's fine. Okay. Just Ms. Riley is in charge of doing those.
Your Honor, if I may make a quick announcement, Your Honor.
Can I
apologize.
interrupt real quick? Chad Marler, let me find Chad on here, but I've assigned you to breakout room 18, I'm sorry. Let me find Mr. Marler on here.
Judge, I have uploaded that order to the chat.
Yes, I have it.
Your Honor, may I make a quick announcement, Your Honor?
Yes, sir.
I have a few things happening beyond my control. I have to go to another Zoom. Can I be excused maybe for 20 minutes or so?
Yes, sir. And Mr. Hernandez, I'll ask you to, you're excused, both of you, until 11:30.
Thank you, Your Honor. Thank you.
Do what now?
The attorney for the other side has to appear in a different Zoom court. I've told him to be back, asked him to be back by 11:30. You're welcome to remain online. You're welcome to be back here at 11:30.
Okay, I have a doctor's appointment at 11:30.
Okay, how long is that likely to last, sir?
It's not going to be very long.
Okay, how about we ask you to be back here at 12:30?
Okay, that'll be perfect.
Okay, 12:30.
All right, thank you.
And Judge, may I approach?
No. Give me a moment. I need to get this saved, or I'll be behind. But Hoffman with one N or two?
It is with one N.
All right, I'm just going to post this to everyone since it's not confidential, and I will ask the clerk's office to grab that, file it.
Joe Rodriguez, you've been invited to a breakout room 19. If you'll please accept that and go in there with Ruben Flores, please.
Okay, so I have posted the order on Hoffman versus Elwood.
Thank you, Judge. May we be excused?
Absolutely.
Thank you.
Thank you, Your Honor.
Okay, does anybody else have a announcement?
Good morning,
Yes,
Judge.
Your Honor. I believe that we're ready. Oh, go ahead, Robbins.
Yes, Judge, we're ready for a plea on Ms. Rosita Favela, Your Honor. Thanks, Tony.
Of course.
All right. And yes, sir, you're breaking up, Mr. Flores.
And we're ready for a plea on Roland Lugo for an MTR, Your Honor.
Okay. Do I have the paperwork on any of that?
No, Your Honor, I'm working on the paperwork, about to send it to Tony Paul Rice.
Okay. All right. Okay. Let me know when that's sent to me. And
Oh, come on.
are the attorneys still conferring in the Jones case?
Yes, Judge, they're still conferring.
This idea.
Does anybody else need a breakout room?
I do, yes, with Brad.
Dawn, I'm sorry, who did you need, sir?
Hey, Tony.
Yeah, Brad Thornton.
It's okay. Hey, can you just confirm that you received the paper?
Mr. Flores, where is Joe Rodriguez? Is he in jail? Hello?
He's not in custody.
Okay, thank you.
You're welcome.
Judge, may we provide an update?
Yes.
Miss Monk and I were able to speak. We have agreed on July 26th as a date to come back, but I have told Miss Monk, my intention is to proceed with a temporary order and not a final trial. And she said that that was fine.
I do have a question though. This is supposed to be a final hearing. This has been ongoing. I don't agree to the temporary orders. The way she spoke with me was that she's going to ask for it and basically get it anyways. This was supposed to be a final hearing on all matters. Her attorney's office messed up and didn't file paperwork, or she's saying my attorney didn't, but we've been to court several times. I don't know what temporary order she's asking for. It's supposed to be a final hearing on all pending matters.
Judge, even though I wasn't the lead counsel on this case, I have been very aware of what's happened on this case. Miss Monk filed this lawsuit. On the day temporary orders were set, she didn't even show up. And so what her attorney did was create an agreement with Attorney Wilson in order to save her the agreement for temporary orders, which were never filed with the court. We have these temporary orders. So the orders either need to be entered. If the court will not enter the orders, we need to have temporary orders because they ask for drug testing. And I think Ms. Monk doesn't want that drug testing to happen. She just wants the court to proceed with final orders. That's not in the best interest of the child. And so what I would like on the 26th, Judge, I'm filing the paperwork today to set it for temp orders.
Okay. When were the temporary orders supposed to have been entered?
Let me look that up, Judge.
I believe it was in March.
I know Lucinda Vickers was on the case. She represented Ms. Monk at the time.
And was that in front of me?
It was. No, March was the withdrawal of Lucinda's, it was February 10th. And it was by Zoom, February 10th by Zoom, and Ms. Monk didn't show up to her own hearing, her own setting.
I had issues with my cell phone.
Okay, all right. What I need to know right now is what judge had the hearing about temporary orders? Or was there a hearing? Was it just supposed to have been agreed to?
It was just an agreement because they waited all day, Judge, for Ms. Monk to show up. And so they didn't proceed in front of any judge, and they just made an agreement for temporary orders since Ms. Monk didn't show up to her own lawsuit.
No, and we had a hearing on May 24th. Judge Ellison was the one judge presiding on that hearing, and his attorney's office messed up. They didn't file whatever was needed to be filed, or they didn't check up on it, and basically they needed to reset it today. They signed the paperwork, the judge signed the paperwork for the reset today, and this is where we're at on it. Today was supposed to be a reset for all final pending matters.
All right, what day were you asking for in July?
July 26th, Judge.
Okay, and was there a hearing last month?
There was a hearing set. It was my understanding that hearing was not had.
May I say something?
No, sir. You can talk to your attorney, sir, but
There was a hearing set. That hearing was not held.
Okay. And you want to ask Mr. Marler, was there a hearing? You're saying there's no hearing was held?
Well, I mean, they came, everyone arrived, it was in person, but it was my understanding that they didn't have an actual hearing.
All right.
It was dropped.
And what's your view on that, Ms. Monk? Was there a hearing?
Yes, there was. Yes, sir, there was a hearing. I have the court report, the record from the court reporter. There was a hearing. Mr. Wilson, I guess, messed up and didn't file paperwork and stuff. So Judge Ellison went ahead and let us reset it and told us that pick a date, which was today, and that we needed to do all final matters on this case today.
Okay. All right. So how many pages is the court reporter's record?
It's 24 pages. I have it in PDF form. I can send it to somebody.
I don't need to see it. All right, Ms. House, what I'm going to ask is that you look at the calendar. Judge Ellison had a hearing. I went back. I was the judge who was doing the Zoom court on the February the 10th. My notes say Megan Monk, no show, reset on request. All right. So Judge Ellison has heard something. I'm going to ask you, I don't know what he determined. I'm going to ask you, Ms. House, to find a date that Judge Ellison is the judge who's going to be here. And that's, you can tell that from the calendar. And y'all can debate at that time whether it's on the merits, temporary orders, or something else.
I can give them those dates, Judge. The June 28th, June 30th, or with Judge Ellison, and July 12th are available with Judge Ellison.
I would like June 28th.
I did not miss work that day. We had spoke about this.
Okay. Judge, if I may, I'm going to set it. She's having voluntarily vacation time. I'm just going to set it. She can file a continuance. I'm just going to set it.
It's not, my husband's mother is sick. We have to go for a week and a half to Arkansas. It's not vacation time.
But it's not on that date. It's not on that date. It's after that date.
I have a full-time job. I cannot keep missing work. At the end of the month, I have invoices to file. I have expense sheets. I have a lot to do at the end of the month, and I explained that to Ms. House, and she agreed.
No.
She agreed to July 26th.
That I did agree, but the judge is saying we need to set it in front of Judge Ellison.
Okay. All right. How about July 12th?
July 12th, and I will be in Arkansas. His mother's ill in the hospital.
Okay. When are you going to be back from Arkansas?
I will be back on the 17th, July 17th.
August 2nd will be the next one, or August the 4th would be the next one with Judge Ellison.
Okay.
Either of those days are fine with me, sir.
And okay, and what was the issue with the 26th?
That's with you, Judge.
Oh. August 2nd is a week later than the 26th.
That's advanced family law. And so what I'm asking for is June 28th and, June 28th or July 26th.
Okay. All right. Ms. Monk, where do you work?
I work with downhole inspection.
Okay.
It's just the end of the month. It's so much, and I'm the office admin. I do it all.
Okay. Where is your office?
My office is about 2 to 3 blocks from the courthouse. It's in Jordanton.
I'll set it for June 28th. I'm going to ask you, you can file a motion for continuance. You can speak to Judge Ellison about taking you first. You can speak to Judge Ellison about taking you last. I'm not going to make a deal for him. I don't know what his schedule is like, but if he has many hours worth of work, he may agree that y'all can come in at 1 p.m. or something like that. Or he may agree that you can leave and come back. I would ask you to address all of that to Judge Ellison. If you're just going 2 blocks away, I would expect that he will work with you.
Okay.
All right, so June the 28th, I said?
Yes, Judge.
All right, so this is it's 17/7/0625.
And is there a time for that, for the initial setting, June 28th?
9 a.m.
All right. And is that in person?
Yes. This was an experiment. I don't know if it's going to be repeated. I think I'm going to go to about 1 day a month, at least, that we have a uncontested docket on Zoom. We're not going to do this again because I don't think it really helps anything to have regular matters like this set on Zoom. Actually, it helped on this that you could appear by Zoom. So 628 merits. Or just, yeah, and I'll just set whatever Judge Ellison had set for today is being reset for 628, and y'all can take that up in front of him, although it does say final hearing. That's how I read his notice. So y'all are both excused. And Mr. Marler.
Thank you, Your Honor.
All right, tell me when we have a plea ready.
Could I get a breakout room with Brandon Mora through Ryan Boyer?
Is Brandon Moya, you said, or who?
Brandon Mora.
And is he in jail or where's he at? Is he on?
He's online. He's on
Okay,
Zoom.
thank you. I invite you to breakout room 2. Brandon Mora, you're going to get a little break pop-up window inviting you to room 2. Please accept that. I'm sorry, Brandon Mora, room 1. Brandon Mora, can you hear us? Does anybody else need a breakout room?
Yes, is anybody there? My doctor's appointment has been moved to 1 o'clock this afternoon. If there's a way I can get in before then, it's even better.
All right, Mr. Hernandez, just hold on. The attorney had already left, so I expect he'll be back at around 11:30. We'll try to get your case in.
Okay, thank you, sir.
Judge, when you get a chance, may I approach?
Go ahead.
Judge, I have a Madison Howard that's set on today pre-trial. She has that case pending, but she has another one that she got arrested on in April that they haven't indicted her on yet. Kenny was supposed to try to get it indicted and make me an offer on both cases, but that has not happened. So I was wondering if you wanted me to remain on docket on the old case or get a new set of dates.
Okay. Do you have any idea when it's going to?
I'm not really sure, Judge. I was talking to Will, and he kind of doesn't really know anything about the case, but he spoke with Kenny, and that's what the message Will gave me was that it's probably be some time before they get the case.
And that's correct, Your Honor. I don't, considering that she got arrested back in April, and the charge is man delivery. So yeah, it could be some time before that case is indicted.
All right. Is she in custody?
She is in custody, Judge.
And what level of offense is she in custody on as opposed to, well, is she in custody on the case that's on the docket or in the new one, or both?
On both.
Okay. What's the level of the case that's on the docket compared to the level of the unindicted case?
They're both first degrees, Your Honor.
Okay. All right. It doesn't matter to me. We can delay it. We can have it remain on the docket.
I'll get with Ms. Riley.
All right. Either way.
Okay.
I mean, it sounds like it's possible that if this was a state jail and the other one's a first degree, I would say, hey, we need to delay it absolutely, because the states, there's no possible way they would ever, I wouldn't think, take a first into account for a state jail. But if they're both first, then may still be able to work them both out.
Thank you, Judge. I'll get with Ms. Riley.
Mr. Flores, you need a new set of trial dates. Is that what you're asking for? Or just a reset date?
Well, I was gonna ask for the whole set, like pre-trial.
Do you want the one that's set for 6/28, 7/29, 7, or is or the immediate one that's set 6/28, 7/14, and 8/9? I mean,
What was the first set of dates?
I'm gonna post them right there. 6/28, 7/20, and 9/7.
I'll take that one.
Okay, I just posted them to you in chat.
And I will post them to everyone.
Mr. Valdez, I sent you a chat note regarding posting the dates, how the judge would like it with cause number, defendant's name, and the dates.
Yes.
Post it in
already-
chat by yourself, please.
I got it.
Thank you.
Can I be excused now?
Yeah, did you post that?
Oh,
You have to post it, sir.
oh, okay. Let me do that.
Thank you.
Thank you.
Lori, Adriana Biggs here. On Cirilo Cedillo, that is a monitor competency where the defendant is in Kerrville State Hospital. And we have not received the updated CME from the hospital. So what I have drafted and sent over to Brian Powers is a hold order to give us 30 days to get the paperwork from Kerrville. So I have sent that over to Brian, and what I'm asking the court to do I'm asking for a reset within those 30 days to make sure, to circle back, whether it's 15 days, 21 days, or 30 days, to make sure that paperwork, but it's gonna be, I'm asking for a reset and submitting an agreed order to the court once I get Brian's signature.
Is July 26th sufficient?
Yes.
And it's basically to monitor the comp eval, is that correct?
That's correct. That's outside the 30 days, so it actually, the hold is only for 30 days if the court
okay.
signs it today.
Okay, so let's see. The 20th, July 20th, how about that? Is that out of the day?
No, that's fine. That'll be fine.
Okay, that's a jury docket call date, but if that's the only date available, then.
Okay, well, yeah, and this should be all paperwork that
Yes,
we can
ma'am.
submit to the court. It's
Okay.
just a matter of getting the proper documentation from Kerrville.
Sure. Okay, so I've reset it to July the 20th then for you.
Okay, thank you.
And Adriana, I'm sorry, where do I need to send the plea documents for Roland Lugo again?
To Chris Benavides. Chris, are you on? District?
Yes, I am. He would have to do it through e-file. The defendant signed the paperwork already?
Yes, we have e-signatures on them.
Okay.
They need to be e-filed then.
Okay, all right, I'll print them off and get them through.
I wasn't sure if Judge Wilson was accepting those directly, Chris, or if they need to be e-filed. So thanks for that clarification.
You're welcome.
Okay, very good. Thank you.
All right, I had the computer muted for a while. Was anyone trying to get in touch with me? No? Okay. I'm here if we get a plea ready.
Judge, I have an announcement before you go on break.
Yeah, I'm not going on break. I'm just doing research. Yes, sir.
Yes, Your Honor. I have two clients who were set for pleas this morning, Mr. Angel Hinojosa and Ms. Rosita Favela. We were ready to proceed with the plea. However, both of my clients are appearing via Zoom instead of in person. And so I'm going to ask the court if I could reset them for an in-person plea due to the fact that they both received letters stating they needed to appear by Zoom and not in person.
Okay, where are they?
Ms. Favela is on Zoom.
No, but by that I mean, well, they just need to drive down to the probation.
I'm right here,
office.
sir.
Okay. How far away from the probation office in Jordanton are they?
I believe Ms. Favela is at her home in San Antonio, Your Honor, and Mr. Angel Hinojosa is at work. And I believe he may work in San Antonio as well.
All right, that's fine. Just reset them for whatever quick day we have available.
Yes, Your Honor.
All right, Ms. Marvel, did you have an announcement? And Ms. Mazaheri?
Yes, Judge, I did. We have reached an agreement for Rule 11. We will we're circulating signatures right now. We will file it with the court. It's for temporary orders.
All right, excellent. Thank you.
Thank you, Judge.
Accept Judge from the recess.
Hey, man, what's up?
Is the judge still there?
Yes.
Yes, Mr. Flores.
Yes, sir. I already did that thing for the lawyer.
All right, I'll look at it.
Your Honor, are you still there?
Yes.
Yes, Your Honor, this is Ms. Sarah Tehidina. I did complete that
Okay,
application.
ma'am, all three of y'all, I'm working on it. Unless something else is going on, the Public Defender's Office will be appointed for everyone. So just hold your horses.
Yes, sir. Thank you.
Okay, I did appoint TRLA to both cases. Tijerina and Flores.
Yes, Your Honor.
What page is Flores on, Judge?
He's not. He's
Oh,
an add-on
okay, I see. Do you have a cause number on that one?
214171.
Thank you, Judge.
Judge,
Yes.
I got reset. Am I allowed to leave or?
Yes, sir. If you've been reset, as long as you know when you're supposed to be here, you can take off.
Okay, thank you, sir. You have a good day.
Ms. Favela, this is your attorney, Alfonso Cabañas. You're excused. I got your reset. I'll call you in a couple of minutes.
Okay, thank you then.
All right, Mr. Hernandez, Mr. Hilly,
I'm here, Your Honor.
Yes.
All right, I didn't know you were back, Mr. Hilly. Um,
Apologize. I apologize.
All right, and Mr. Hilly, in Ovation Services versus Eugene Hernandez et al., you filed a motion for default judgment?
Oh, yes, and he made an appearance, Your Honor.
Yes.
So I'm not sure whether the court wants to set it for trial.
Well, you said you didn't want to confer, so yes, you want to get on the court administrator's website, go to the calendar and pick a day with 42 days out. And when we're in court in Atascosa County on civil days or civil dockets.
Thank you, Your Honor.
Can I just pay it? Can I just pay it off, Your Honor?
All right, sir, you're going to need to speak to Mr. Hilly about that.
Well, I've been wanting to talk to him and nobody wants to talk. I call his office. Nobody wants to talk.
No, I can get his number. I'm just local attorney, local lawyer.
All right, Mr. Hilly. Okay. Mr. Hilly, you broke up. I can't understand that.
Can I get his number and I can contact him?
Okay.
Because I'm just local lawyer. I'm not them.
Okay. Hold on just a moment. And I think you're trying to tell me that you are just the local counsel.
Yes.
Okay. All right, Mr. Hernandez, I've been in Mr. Hilly's shoe. What local counsel means is typically it'll be a big bank or financial institution and they'll hire an attorney fairly close to the local court to appear in court for them, but you're not representing the company as a general attorney. You're just there to prove up a default judgment or to argue a motion for summary judgment or something. But I've just sent both of you an invitation to a breakout room. If you look down at the bottom of your screen, Mr. Hernandez, you should see a little blue box. And if you'll click on that, you'll go to a individual electronic room where you and Mr. Hilly can confer.
Okay, I'll push the join button right now.
All right, he just disappeared. Okay, if y'all will let me know when we're ready to go on a plea bargain or plea.
Judge, you're gonna need us anymore?
I don't believe so. I mean, you know, every time I release you, it seems like somebody wanders in late.
That's why we've been waiting to see anything chop. Just
It
happens
is
right
almost the noon hour.
Right.
Ms. Harkins, the order you sent me earlier,
Judge, I was informed after I uploaded those that you actually signed them on Friday. I wasn't aware, so we're good.
Okay, excellent, because I was going to say they're corrupted and they're not working.
Okay, well, we're
But
good.
it doesn't matter.
Okay. And Judge, I do have a plea on Mark Olivan. My office e-filed that, so as soon as that's ready to go, then we're ready. He's in custody.
Okay. It would be much better if you have if you can just post a PDF copy in chat,
Okay, I'll do that as well.
because it's the judge's review function on e-file Texas is not very user friendly. You either zoom out to where you can't read anything, or you zoom way in, and then you have to move around searching for whatever you're looking for. There's nothing in between.
Yes, Your Honor, I'll upload that right now.
Judge, and they just e-file them because then I'll save them and then I send them to you.
Okay, as long as somebody gets them to me.
Apparently the e-filing system is giving us a hard time, of course. So it might be quicker to upload it to chat. We don't know what's going on with it.
Okay.
I'm in approximately the same boat on my end, Your Honor, for a plea.
Okay, that's great. Just upload it in chat.
Yes, Your Honor. Thank you.
And Judge, one thing I noticed on some of these resets is people have dates for the August trial setting and they're resetting to the September trial setting. Was that the court's intent to reset to another trial date without approaching the court or
No, but I didn't look at the dates that were posted.
yeah, this happened 2, maybe 3 times. Jonathan Trevino was one of them.
All right, I've only got to the first reset. That was Mr. Serta. So I will work my way through and we'll see when we find one.
Okay.
I said this was an experiment. We're going to turn this into about a once or twice a month Zoom uncontested docket. But where the defendants are in the probation or somewhere in whatever county, we'll have to make sure we have that arranged if we do it. We'll have to work that out.
Judge, I'm told that our plea documents on Roland Lugo have been e-filed. I'm having trouble uploading them to chat on my phone because our router is out at my office. But they should be available on e-filing whenever the court's ready.
I see it right now. Let me get that to the judge.
Thank you.
Frisbee.
Your Honor, or Ms. Riley, can I get put in breakout room 17, please?
Come on, machine. All right, I just posted the waiver of arraignment. I'll ask Chris to grab that. It's on Mora. All right, Olivan. All right, and Mr. Hilly, my computer is doing something. Did you have an announcement on a reset date or?
Oh, I'm still having the law firm look for a date. Maybe, can he be excused? Can we follow up with him later? Can he be excused? Or Mr. Hernandez? Or you want to stay on?
Well, let's get him to stay on. Mr. Hernandez? Is he still in the breakout rooms? Yes, he's still in the breakout room. Right. Ms. Riley, can you go in there and get him back out?
Yes, Judge, who did you need?
Number 19,
Okay.
Mr. Hernandez.
Sure.
They really need a way for the host to be able to pull just one person out of the breakout room.
Yeah, this,
You have to either close them all or go in there yourself.
yeah, it's crazy. You can ask them to move, but they don't always move to the main menu either. It doesn't allow you to move them to the main session.
Right.
But let me get in there real quick.
Be on a, can I come at 1:30 because I have a hard time reaching them to get a date right now.
I'm sorry?
Could I be excused until 1:30 so that I can go to another?
All right. Oh, Mr.
Can I be
Healy, I think we're
excused
going
to
to
another?
just, you're either going to have an agreement for dates or it'll be reset on request, but I want to get Mr. Hernandez back here and get him to put an address on the record because he's just made a verbal appearance and you don't have an address to send him a notice at. All right, Mr. Hernandez, I'm asking you to unmute.
Yes, sir.
All right. Mr. Hilly needs an address so that the company he represents, if they need to send you notices, can send you notices. What is your mailing address?
It's 530 Riggins Rock Pit Road,
Okay.
Pleasanton, Texas 78064.
.530 Riggins Rock Pit Road.
That's correct.
Okay. All right. And I believe Mr. Hilly's announcement is that he does not have a date that he knows that his client is available to have this reset to, so he's going to have to get it reset at another time. Is that correct,
Yes.
Mr. Hilly? Hello?
Well, is there anybody I can contact just to pay it off and get it over and done with?
I would hope so, but sir, I
I have your phone number. I have your phone number, sir, and I'll update you very soon.
I mean, I've been in and out of the hospital for the last.
All right.
And I would like to take care of it while I am out of the hospital now.
Okay. All right. Mr. Hilly, do you have okay. Y'all need to, do you have a phone number, do you have Mr. Hilly's phone number, Mr. Hernandez?
No, I don't. And I don't even have a pen with me.
Okay. All right. I'm going to ask him to send a letter with the contact information for his client to your address, okay?
Okay.
All right, then you're excused, sir. Thank you.
All right. Thank you, sir.
All right, Mr. Hilly, I'll see you at 1:30.
Thank you.
Okay, Mark Andrew Olivan, are we ready on that?
Ready, Your Honor.
And is Mr. Olivan in custody?
Yes, Judge.
I ask the jail to get him.
Yes, Judge.
Okay, if someone will let me know when he gets here.
Yes, Your Honor.
Ms. Polrez, is your client in custody also?
No, Your Honor, he's on Zoom.
Is he at the probation office?
No, Your Honor. We were not aware that he would need to be there.
Yes.
He can get there today.
All right, if you want to have him head over, because we need to have the bailiff be able to get there and get a thumbprint. And
Yes, Your Honor. I will speak with him and get him over there as soon as possible. Would it be good to schedule that for maybe 1:30?
that's fine.
Okay, very good. Thank you, Your Honor.
All right, calling cause number 20-02-0041, State versus Mark Andrew Olivan. Are both sides ready?
Defense is ready, Judge.
Okay.
State's ready.
Are you Mark Andrew Olivan?
Yes, sir. That's correct.
That's your true and correct name.
Yes, sir.
All right, Mr. Olivan, can you speak, read, and write the English language?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Okay, despite your representation that you are a United States citizen, I need to caution you that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you still wish to enter a plea today?
Yes.
Do you have any history of mental health problems or mental illness?
Yes, sir.
What sort of problems?
Anxiety.
Has that issue kept you from being able to speak with your attorney about this matter?
No.
Have you been able to understand what Ms. Harkins has told you about what your rights are and what your options are?
Yes.
Have you been able to make her understand what it is you want to do?
Yes.
Counsel, do you believe your client's competent to stand trial?
Yes, Your Honor. And just for the record, at the beginning of this case, we did do an evaluation on my client and he was found competent. And I've had many conversations with him and it's my opinion that he is competent.
Okay. All right, sir. You stand charged by indictment with the state jail felony offense of unauthorized use of a motor vehicle. Specifically, it's alleged that in Atascosa County, on or about August the 26th, 2019, that you intentionally or knowingly operated a motor-propelled vehicle, an automobile, without the effective consent of Armando Diaz, the owner thereof. All right. That alleges a, give me just a moment. State jail felony, which is punishable by confinement for not less than 180 days and not more than 2 years, and by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes, Your Honor.
Do you understand that the plea bargain agreement you have with the state is not binding on me? I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea?
Yes, sir.
You understand that if I do follow the plea bargain, that you will not be able to appeal this matter?
Yes, sir. Understood.
I want to show you some documents that appear to have your signature.
Okay.
All right. And does everybody see the plea bargain papers?
Yes, Your Honor.
Okay, because it put a green box around this for a moment and that went away. All right, sir, these documents are titled Admonitions to the Defendant for Plea to the Court. And I want to ask you on paragraph 2.11, is that your signature?
Yes, sir.
And the next page where it says verification?
Yes, sir.
And do you swear or affirm that everything above your signature where it says verification is true and correct?
Yes, sir.
And did you also sign at the certification of appeal? Here at the bottom?
Yes, sir.
The agreed punishment recommendations?
Yes, sir.
Waiver of preservation of evidence?
Yes, sir.
and the discovery compliance certificate.
Yes, sir.
Did you read these documents yourself, or did Ms. Harkins read them to you?
Yes, we went over it.
Did you understand these documents before you signed them?
Yes, sir.
And are you satisfied with the work your attorney has done for you?
Yes, sir.
All right, counsel, do you believe your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
Yes, Your Honor. Yes,
Okay,
Your Honor.
sorry, yes, I'm sorry, my computer was just locking up. All right, I'll find that the defendant made his waivers of right and his stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And I'll ask you, sir, to the offense alleged in the indictment, unauthorized use of a motor vehicle, do you plead guilty or not guilty?
No contest.
You understand that a plea of no contest might be different than a plea of guilty if you get into a civil lawsuit over this matter. For instance, if Mr. Diaz was to sue you for stealing his automobile, it might make a difference in that civil lawsuit whether your plea today is guilty or no contest. But that for all purposes inside this criminal case, a plea of no contest is the same as a plea of guilty?
Yes, I'm aware.
Has anybody harmed or threatened you or anyone close to you for your plea?
No, sir.
Has anybody promised you an early release from your sentence?
No.
Has anybody promised you anything other than what the state has agreed to do in the plea bargain to get you to enter this plea?
No.
All right. I'll find that you made your plea voluntarily and you're not under any compulsion in making it, and I'll accept it. And I'll ask what evidence the state has.
The state offers Exhibit 1 and it's Attachment A.
No objection.
All right, without objection, states Exhibit 1 is Attachment A are admitted into evidence. Do both sides rest and close?
The state does.
Defense does.
All right, give me a moment to look at the attachment.
Your Honor, am I still needed?
Who are you?
Sarah Louise Tijerina.
I know you may have reset dates on you. Go ahead, ma'am.
Thank you, sir.
Okay, I'll find there is enough evidence to substantiate the defendant's guilt. Are both sides ready for punishment?
State's ready.
Defense is ready.
Okay. What is the plea bargain in this case?
Plea bargain in this case is for 15 months in the state jail division. And there's credit for 328 days served. There's a court cost of $315 as well.
Okay. All right, and let me ask, first of all, is there a pre-sentence investigation or a waiver of one?
No, Your Honor, and my client will waive the PSL.
Okay, all right. And did you hear what was read into the record, Mr. Olivan?
Yes.
Is that your plea bargain with the state?
Yes.
Did the state's attorney add anything or leave anything out?
No.
All right, and are there any other cases you have pending?
Yes.
What sort of cases?
Medina County. Fleeing in a vehicle, but it was.
Was there any request for restitution from the victim in this case?
Just a second, Judge. I don't believe so.
Not that I'm aware, Judge.
No, Judge, we never received our
letters back. All right, then I'll find I have enough evidence to make a decision without a precedence investigation. I will follow the plea bargain agreement. I'll find the defendant guilty of the offense of unauthorized use of a motor vehicle and sentence him to 15 months confinement plus court cost. Is there any legal reason why a sentence should not now be imposed?
No, Your Honor.
All right, then. It is the order, judgment, decree of the court that you be taken by the sheriff of Atascosa County and transported to the authorized receiving agent of the Department of Criminal Justice. You will be confined for a period of 15 months. Your sentence will commence today. It will run concurrently with any other sentence that you may be under, and you will receive credit for all the time you have spent so far in jail on this charge. You understand, sir, that because I have followed the plea bargain agreement that you have waived the right to appeal and you may not appeal?
Sir, understood. I understand.
All right. Okay, I will find that you made your post-trial waivers knowingly, intelligently, and voluntarily, and I will approve them. And I will certify to the Court of Appeals that you have waived the right to appeal and may not appeal. All right. Okay, and do we have a thumbprint? If somebody can give me the thumbprint, I will match it up with the judgment and sign it. Because I forwarded you the judgment. I'm not sure who to send it to get a thumbprint. I can. It is posted in the chat. If the jail can print it. Hopefully the jail can get it down. All right, I'll just wait on that. Does anybody else have anything ready?
Judge, that's all I have left besides what I've posted in the chat. So may I be excused?
Yes.
Thank you.
Okay, do we have any other defense? Are the attorneys still working on anything?
Judge, I'm still working on getting a waiver of agreement in for Mr. Flores. I just need to break out.
Because I don't know of anything pending on my end. I think we just have that MTR as far as please.
That's correct, Your Honor. That's all I have left.
Oh, I thought we had all kinds of stuff. Okay, I don't know why I thought that. All right, well, let me go. I'm going through the docket, the notes.
I missed who wanted a breakout room, Judge. Did someone ask for one?
Mr. Lamerson, but I'm not certain.
Did somebody ask for Flores?
Yes.
Yes,
Yes.
Mr. Lamerson did. I'm not sure what happened to him.
Let me see if he went to that breakout room. Maybe he went into a room.
Okay.
All right, well.
No, I don't know where he went.
His power just went out.
Oh,
I'll meet with Mr. Flores.
okay. I'll get y'all in a breakout room. Mr. Flores, you're gonna get a breakout room 2. You're gonna get an invite to that. So if you'll join that, please.
Okay.
Let me find you on here. All right, you're gonna get a pop-up window inviting you to that, sir.
All right, when did Ed Bartolome set Joseph Guzman for? Because what he posted is 6:26.
And down below, he made a correction, Judge,
Oh,
to
okay.
6:28.
That's better. I didn't plan to be here on Saturday. I could avoid it.
Exactly. You want to go over some of the docket, Judge?
Not for a minute. I'm trying to.
Okay, I'm sorry.
All right. When Joe Maldonado the attorney posted 7/26. That's a plea date, not a pretrial date. He says 7/26 plea. So did anybody discuss that with him?
Actually, he asked me if that date was okay, Judge, and I was under the impression it was an okay reset date. And so I thought, well, on Joe Maldonado, yes, on that one, yeah. I told him that it was okay. And
Okay, all right.
actually, Judge, I actually think he did intend to set it that date for a possible plea. So
Okay.
now that my memory is serving me correctly. He said he's getting plea paperwork to Kenny.
Okay, did Juan Herrera appear?
Yes, Judge, sorry about that. My power went out for a second. Juan Herrera did appear, Judge. He was in person there at the courthouse, and then he got on the Zoom as well.
Okay.
Smell good.
And then when he stops talking, just.
Your Honor?
Yes.
My name is Daniel Beckworth.
All right, Mr. Beckworth, you have two electronic devices going that are hooked up to this meeting, is that correct?
I can understand you. You need to turn your deal. Try and turn this other one off. And turn the volume on. Okay. What did you say?
Yeah, go ahead. How you can talk to him. You can go back so he can see you to the camera. You see where you're at right there?
I can't hear you.
You see where you're at right there? He can see you to the camera.
Okay,
Yes,
that sounds better.
I can't hear him on here though. The volume up. There we go. Okay. Go ahead. Your Honor?
Yes.
My name is Daniel Beckworth. Earlier, Mr. Clanton had announced he was taking ourselves off our case. I'm trying to find out what is going on with our case. He's refused to talk to us for months on end. We finally got an appointment with him on the 7th of May to discuss our case with him. He told us that.
All right, hold on, sir. What?
Would you like a case number?
Hold on. Yes.
20-03-0314-CVA.
All right, sir. This case was set for a motion to withdraw and a motion for summary judgment. And Mr. Clanton withdrew this morning from representing you.
As of last Friday, according to the court clerk that sent me the Zoom meeting information, y'all had not received any paperwork from Mr. Clanton. The 7th of March, when I saw him, he wanted to withdraw from my case, wanted me to sign a document assuming blame for his withdrawal, claiming he had a personality conflict, which I was totally unaware of. He refused to tell me what the personality conflict was, where even a problem existed. Personally, I have no problem with him removing himself from my case. On the advice of your clerk, I went and asked another attorney about the document he wanted me to sign. I was told that if I signed it, I would be accepting blame. Saturday on the 8th, I received paperwork from Mr. Clanton, unsigned. He was filing to withdraw himself from my case. And I was under the impression from what he told me that he had sent it to y'all. As of last Friday, your clerk said he did not.
All right, so where are we going with this, sir? He's been allowed to withdraw as your attorney, and my understanding is that you're good with that. You don't want him to be your attorney.
Correct. And I've hired another attorney on the 11th. His name is Reed Green, Greene.
Okay, and sir, there are no settings that I am aware of right now. The note I have is reset on request, meaning that someone is going to have to go in and file a notice of setting or file a motion to have something set. There are no settings right now.
Okay, so is the case still open then?
Yes.
All right. And from
So
what I'm
if you have a
understanding,
new attorney, the new attorney just needs to go to the e-file system and make an appearance.
what I understand, my current attorney hasn't filed paperwork with y'all, even saying he's on the case or anything. So I'm not sure
Mr.
how. this-
Beckworth, I haven't gone and looked it up, so I couldn't tell you that. I can tell you that all he needs to do is just come in and make an appearance electronically, and then he will be the attorney of record.
Okay, well, my new attorney says the insurance company wants to come out and inspect our property on the 28th.
All right, sir, I have no idea, and I can't advise you on that one way or another.
All right. Well, thank you much.
Yes, sir. Have a good day.
Judge, I've posted a waiver on Mr. Jesus Flores. Is he free to leave?
Give me just a moment. I'm working my way down and all right, did Ciro Cedillo appear, or is he in custody?
I think Miss Biggs said he was at the Kerrville State Hospital, Judge.
Yes.
That's correct, Your Honor. And so I've emailed the staff at Kerrville that I normally contact and have not been able to get a CME. And so I have submitted an order, a holding order that will give us 30 days to get that paperwork. I have discussed this case with the doctor, the treating physician, and she anticipated he would not ever be restored to competency. So it's just a matter of getting the paperwork from them, the updated paperwork.
Okay. And who's on the other side?
Brian Powers, and we've been in contact last week, and right now he's picking a jury. He's helping Stephen Barrera pick a jury in Bernie.
Okay.
But forwarded the order to him, and we've just.
All right, excellent.
And it has a reset date, July 20th too, Judge. I'm not sure if you see that.
Yes, that's what I came to, was on that.
Thank you.
Okay, here's a waiver of arraignment on Sarah Louise.
I'm not sure if you can open that first one. He reposted it. I wasn't able to open it, Judge, so he reposted it again. It looked like it might have been
No,
corrupted.
It's corrupt.
Yes, he reposted it again.
Okay, and I just posted the Jesus Flores arraignment waiver, rather. And the Tejerina waiver. Okay, I think that's everything. I'm gonna start going over the docket.
Yes, Judge, please.
Okay, Wilmer, 628. Monitor commitment, I guess.
Yes.
Cedillo, 720. Monitor the next 3 cases, 726. Guzman, 628. And the default dates, there's not that many of them, but it's the September jury dates, which is 628 pretrial, 720 docket call, 9/7 jury selection.
Okay.
So Joaquin Martinez default dates.
He has 6/28, 7/14, and 8/9, Judge. She asked for a pretrial of 6/28 on that one.
All right. So it's remain on docket and add 628.
Yes, sir.
Okay, well, never mind. All right, Anthony Garcia, I don't have anything.
I don't have anything either.
That's the guy that had the 3 PR bond orders, Judge, that you already signed.
All right, does he have dates for anything?
I'm not sure.
And this is Miss Harkin's case, right?
Yes. All right, we'll come back. I'm going to ask Ms. Riley when she gets a chance to check. Does he have dates? If not, we need to get him dates. Roland Lugo, I have nothing. Or is that the plea we're going to do?
I think that's the plea, Judge.
All right.
That's correct, Your Honor.
Eric Michael Gomez.
I had no present, not present.
Next time, yeah. Estrada, 823 monitor commitment.
Yes.
Anthony Garcia.
That's the same one that's making
Same
those
one,
orders.
okay. Garces, 628, 714. Serta, 8-4 to plea. Olavan, final judgment. Reyna showed up late, but he's remain on docket, I think.
Yes.
The rest of the pages remain on docket.
Correct.
Next page, Hinojosa, 628 plea. Madison Howard, the default dates where they bumped it up to the September jury.
Yeah, 6/28, 7/20, and 9/7, Judge.
Alvarado, remain on docket.
Yes.
Fowler, 8-4 plea. Oliva,
I don't think I got anything on that, but it's like remain on docket, I believe, Judge.
Did he appear?
I had a yes.
He
I
did.
had him
He-
present. Trevino, default dates.
6/28, 7/20, and 9/7, Judge.
Yes, that's the default dates.
Okay.
Bailey, 7/26 plea. All right, John Thomas Garcia. Does that remain on docket for everything?
Yes, Judge. Remain on docket.
Mario Bravo,
I don't have anything on that one.
I last have for a bench warrant, Judge. I don't know if he was ever brought over.
okay. Remain on docket.
I don't know if he has dates on that one. Are you talking about? You
Yeah,
said
I'm gonna
Bravo?
ask you to check dates.
Okay.
Not, we'll give them some.
Yes, sir.
Garces, well, there's several of these where it's just 6/28 and 7/14.
Yes, an 8/9 on that one. I have 8/9 as well
All right.
for Garson's. And Gonzalez remain on docket.
Yes, and TRLA. Cantu and Effington remain on docket. Viesca, 6/28, 7/14, 8/9.
Yes.
Garcia remain on docket. Stagg, 7/26. And why did that jump to 7/26? Is that supposed to be a plea or?
Your Honor, Mr. Lamison told me that,
I'm so sorry, which case was it? My apologies.
Staggs. Yeah.
Yes, Mr. Staggs is in rehab right now up in Dallas, Judge.
Okay.
Spoke with Mr. Thornton and he agreed to keep it off trial docket and to reset for 7/26 via Zoom.
Okay, that's fine. Gaitan,
Remain on docket.
Samaniego remain on docket. Connie Rodriguez.
I have remain on docket, Judge. And Joe
Joe Lewis.
Rodriguez remain on docket, Judge.
Favela, 6/28 plea. Eric Cortez,
6/28 to plea.
Santos remain on docket.
Yes.
Olivas remain on docket. Well, actually, it says 6/28, so I guess add 6/28 and remain on docket.
Okay.
Laura Gonzalez David Wilkerson's been retained, he informs us, remain on docket. Carlos McDonald, I don't have anything.
I have him in jail in Medina County is all it shows.
Oh, Medina County, okay, I had him in custody.
Deputy's credit work.
So bench warrant from Medina,
Do we need a date on that one, Judge?
yes. That's the guy they said they weren't gonna give up until August, is that he or?
Yeah, that's the one. I believe that's the one.
9/13,
9/13, okay.
I think that's the first day in September. Garcia remain on docket. Frisbee, 7/26. Reheña remain on docket. Sanchez remain on docket. Sarah Louise Tijerina. What dates did she get?
6/28, 7/20, and 9/7, Judge.
All right, so default dates. McDonald, 720, oh, Maldonado rather, 7/26. Anthony Garcia, we're checking on. Mora, the default dates. Juan Garces, 6/28, 7/14. And Jesus Flores, I see Mr. Flores, I think is still there. We need to get dates on him.
There's 6/28, 7/20, and 9/7, Judge, on those for
Okay.
Jesus.
Default dates.
Flores.
Judge, did you script Brandon Mora? Skip him.
He has the default dates.
Okay, thank you, sir.
6/28.
Sorry, Judge. What was the dates again?
All right, Mr. Flores, get with your attorney on that.
Okay.
Yes. Mr. Flores, I guess if you, after docket, if you could put us in the breakout room, Ms. Rowley.
Sure.
Hey, Judge, on Anthony Garcia. So I spoke with Megan about him. So apparently he got released on Friday. I don't think we should do an eyesight. I don't even know if he was aware to show up to court today. I think what we should do is do a clerk's letter and set it for maybe a month out. I'm getting from Megan his contact info, so I can email that to Chris or put in, or yeah, I'll just email it to Chris once I get that.
Okay.
What
June
dates?
20th.
June 20th. You said June 20th, Judge? That's not a.
No, July 20th, I'm sorry. A month, well, it said a month. Okay, so he was not in custody, he was released, but it's gonna be 7/20, all three arraignment. Or disappear. So is Eric Gomez the only nice eye we have? It's the only one I show. All right, well, like I said, I thought we had a lot more pleas. I wouldn't have given them until 1:30. I think I said 1:30, so I'll see everybody back at 1:30.
Yes, sir.
I'll start looking at my emails. Okay, we're in recess until 1:30. I think TRLA, I believe we're finished with you, if you want to take off.
Yes, I just wanted to talk to Mr. Flores real quick about his dates.
I'm here.
Let me get y'all in a room, okay?
Okay.
All right, thank you.
All right.
You're welcome.
Need like an umbrella over my head. These lights are so bright in here. Okay, I'll see y'all at 12:30 at 1.
Hey, Sus, I sent you an invite to room 11.
All right, Lori, are you still there?
Yes, Judge, I am, and I have a note on that one case with Bravo on that bench warrant to Bear County. They said he was released on bond on May the 24th.
Oh. Well, if we need to check and see if he got notice. All right, I may have just caused a shooting.
What?
Hopefully not. Will you get me do we have a telephone number? The case at the bottom of page 1 of the civil docket, Daniel Beckworth.
Yes. Do I have what?
That's not the guy that withdrew. It was the case above it, a couple above it. It was James Thurman, not Daniel Beckworth, whose attorney withdrew. So I told him his attorney quit on him, and that didn't happen. So if you could give me a telephone number for Mr. Clanton, I want to call him up and apologize and tell him you may have a.
Okay. Let me see if I can get that. You said you need Mr. Clanton's phone number?
Yes, him or William Thorne. William Thorne is who appeared today, I think. And I didn't call Doug Daniels' case, but he wasn't here on that writ of habeas corpus.
I believe that one, let's see, did it get dropped? It was dropped by an agreement, Judge. I'm sorry, I didn't tell you that. I think I was going crazy with these breakout rooms and everybody talking and
That's great. That's
going, but it was dropped.
Okay, we're not going to do this again. This was a mistake. Now I know, but I am going to, I'll think about it. I'll get something written up. I am going to go to pardon me, at least once a month, a Zoom uncontested hearing.
Okay.
We'll have to just spread the word.
Do you want me to post Mr. Clanton? You want me to call Mr. Clanton myself, or are you going to call him, or what?
I'll do it. I'll do it.
Do you want me to post his number in chat so you'll have it?
Please.
Or no, I won't say broadcast it.
Sure.
Judge, Sean Kindle's on TRLA. Are we free to go?
Yes, sir.
All right. Thank you.
Good day.
All right, let's see. I'm sorry. And Thorne was the other guy's name, right?
Yes. And what did they announce? Just that they were dropping it? Let me go and look at my filings for today.
I just showed drop reset on request.
Yeah. Yeah, I got the wrong one. Okay. Thank you. I'm going to call him right now.
I think the the petitioner had said that on the 16th, though. Said I think he got a letter from Mr. Clanton saying he was going to drop the case.
Okay. Well, I told him incorrectly.
Yes, sir. You're not muted, Judge, just so that you know.
Okay, that number rang, but whenever it rang, it said Derek Emmons. He's an attorney.
See if I can find another way to find it, Judge.
Let me see if I can log on to the district clerk and pull that case up.
I think I'm in it right now, actually.
Okay.
He posted a letter.
And they may be working together. That's just news to me if they are.
I'm gonna get out of it so you can get in, Judge.
We can only have one at a time?
Well, I don't know. I'm trying to look at him at the State Bar of Texas. I didn't find him. There he is. That's, oh, it's 0800, I think. 226-0800, Judge.
Right.
On the state barcode, that's kind of what I found.
Right, yeah, that letter is from the defense counsel. So let me go back to.
I think I inadvertently gave you the wrong number. 0800 are the last four numbers. I think I gave you 2800.
Okay. Yes, that's it. All right, so let me call that number. Thank you.
Yes, sir.
Okay, he says he has filed a motion to withdraw. He just didn't have it set. So I'm going to go in my judge's queue and hopefully I'll find it in there.
See it in the coordinator's queue, Judge.
What's that?
I don't see it in the coordinator queue, and I don't think it's with you either.
All right, well, I need to look at it anyway, but
Okay.
I'll start on that. Thanks.
Yes, sir.
This is Tony Poll. He's just announcing I'm back for Roland Lugo's plea.
Okay, is he at the probation yet?
He should be, Your Honor. He said he was going to go there and should be there about 1:30.
He
Okay.
hasn't arrived yet, Your Honor.
All right, I'll be right back.
Very good. Thank you, Your Honor.
All right. Mr. Hilly, I see you're back.
Yes, Your Honor. And I have a mediation going on at the same time. So if you don't hear me, but I'm ready to present my default judgment whenever it court is on my other case.
Okay, I have looked it over and it looks fine. Let me go back to workspace. I returned the judgment in the Hernandez case to the clerk.
So everything is in order on the other case then?
Yes, I've got to say, do you have another copy of the judgment?
I can make sure they e-file it to you promptly. I can
Well,
make
I
sure.
mean, they e-filed a copy, but it's not very legible.
Wow. Let me just tell them to resubmit it then.
Yes, the other one was crystal clear.
Okay. I'll tell them to remedy that right away, Your Honor.
Okay.
Good to see you. Last time I saw you was in the CPS mediation.
It's been a while. All right, so I'm going to put what? I'm going to put more legible copy will be filed.
I appreciate you. I will get on it right away.
All right, have a good day, sir.
You too. Good to see you, Your Honor. Thank you.
You too.
Bye.
Judge, Jennifer's going to get on here, but on that Jones case, I missed the notes on that one. Can you tell me what happened with the Jason Jones, Elvada Jones with the Rashim Mazahede and Karen Marvel?
They have a Rule 11 agreement.
Okay. So Jennifer's going to come on. I'm going to make her host, but I just have to make a note to the jail on some cases.
Okay.
Quick.
All right, State versus Roland Lugo.
Yes, I'm here.
And we're ready, Your Honor.
Okay. All right. Is the state ready?
State's ready, Your Honor.
Okay. You got the short straw, huh?
I did. We're all good.
Okay. All right.
With me.
Are you Roland Luis Lugo?
Yes, Your Honor.
And are you the same individual who on August the 26th, 2019, was placed on 2 years deferred adjudication probation for the lesser included Class A misdemeanor of assault causing bodily injury?
Yes, Your Honor.
Okay. And you understand, sir, that on that day, the judge found there was enough evidence to find that you were guilty of that offense, but did not do so. The judge put you on deferred adjudication probation. And if you successfully complete that, the case against you will be dismissed and you'll have no conviction. But the state has alleged that you have violated the terms of your deferred adjudication probation. And if they can show that that is true, then you could be found guilty and you could be sentenced to anything that's a legal sentence for a Class A misdemeanor, which would be up to 1 year in the county jail. Was this deferred or no? It was 1 year.
I believe it was a regular
Okay.
Probation, community supervision.
I misread that. You were placed. You were given a sentence of 1 year in the Atascosa County Jail with probated for 2 years. All right. And the state alleges that you have violated rule number 1 of your probation. And I don't actually have a copy of the state's exhibit.
Oh, you don't, Your Honor?
No, I should have.
That should have been e-filed with.
I have the Roland Lugo MTR plea pack, but that's.
But there's no attachment?
No attachment.
That may have been my office's fault, Your Honor. We should have attached that when we e-filed it.
Well, I've been sitting here for 45 minutes. I should have looked before now.
I'll send it to the court. Oh, shoot. Of course, I sent it via PBK as opposed to an email. So now I got to go to PBK and open it.
What's PBK?
Our database.
Okay.
So instead of just sending it via email, so I don't have a record of it. So I'll have to just pull it up, sir.
Go ahead.
And as usual, everything's just sort of slow on Mondays. Mr. Tony, do you have it in your email? Q?
I do. I'm on my phone though, so let me see if I can pull it up.
Okay. Well, give me a second then. The throbber is going, so everything's just slow for me. I'm sorry.
I can probably go to the clerk's room, get it. Let me see.
Or Lara? Is Lara on? She may have it and
Yeah, because I don't have it, Judge. It's not part of the plea that I got.
Let me try to put it on
But
chat.
it's usually just the attachment. So let me see here. Criminal case.
Yeah, but
inquiry.
I need to have I need to have my proof. Yeah, so I'm gonna have to close mine and reopen it.
I'm working on sending it right now too.
Yeah, because it's not doing anything.
Who should I send it to?
Just post it in chat to me. Is
Oh,
good.
well, let me see if I can do that on my phone.
Oh, I don't think you can.
I was trying to do that earlier and it wasn't working. Let me see.
Yeah, my database isn't responding, Your Honor.
Adrian, if I just send that to you, can you just forward
Yes,
it
if
to
you
where
send
we
it to
can
me via email, I'll just send it to the judge.
go? Okay.
You just need the violation report, right?
Right, that's the only thing that I attached.
Here, I'll do it right now. I can do it.
Okay, you could just upload it to the chat or via email, right, Judge? We're just waiting.
Yes, the chat is perfect. Email will work also.
And I apologize.
No, I said I should have looked. I don't actually see the, here's the motion to revoke. It says warrant issued. Let me see here.
Adriana, that should be headed your way right now.
Okay.
Okay, and the state's proceeding on rule violation number 1.
Yes, Your Honor. And there are two different instances of conduct on there. So we're proceeding on both.
Okay. All right, sir. Specifically, the state has alleged that you violated rule number 1 of your probation, which is not to commit another offense against the United States or any of the several states. Specifically, they allege that on or about September 7th, 2019, that you appeared in a public place, Chili's Bar and Grill in Pleasanton, Texas, under the influence to a degree that you were in danger to yourself or others. That alleges the offense of public intoxication. It's also alleged that on or about the 23rd of February, 2021, that you operated a motor vehicle in a public place while you were intoxicated due to the introduction of alcohol into the body, which alleges a Class B misdemeanor. So do you understand what it is that the state's alleging that you have done wrong? Mr. Lugo?
Yes,
Do you understand what the state's alleging that you've done wrong?
yes, I do.
Okay. Do you understand that the plea bargain agreement you have with the state is not binding on me? I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea.
Yes,
Okay. And if I do follow the plea bargain agreement in this case, and the sentence I impose is not harder on you than what you've agreed to, do you understand that you will not be able to appeal this matter?
yes, Your Honor.
Okay. I want to show you some documents that appear to have your signature. They're titled Trial Court's Certification of Defendant. Oh, no, they're not. Go back up at the top. They're titled Written Waiver and Consent to Stipulation of Testimony, Motion to Revoke or Adjudicate. Let me ask you on paragraph, page 3, is this your signature? The electronic signature?
I cannot see it.
All right. All right, sir. Can you see it now?
Yes, yes, Your Honor.
And is that your signature?
Yes,
And do you swear or affirm that everything above your signature is true and correct?
yes,
All right. And is this also your signature on the plea bargain agreement?
yes, Your Honor.
And on the written waiver of time to give notice of appeal?
Yes, Your Honor.
On the court certification of appeal?
Yes, Your Honor.
All right. Did you read these documents yourself, or did Mr. Polrees read them to you?
Mr. Polrees.
All right. Did you understand these documents before you signed them?
Yes, Your Honor.
And are you satisfied with the work your attorney has done for you?
Yes, Your Honor.
All right. Counsel, do you believe that your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
Yes, Your Honor.
Find that the defendant made his waivers of right and stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And I will ask you, sir, to the allegation, first allegation, that you committed the offense of public intoxication while you were on this probation case. Is that true or not true?
True.
And to the second allegation, the allegation that you committed the offense of misdemeanor driving while intoxicated. Is that true or not true?
True.
Okay, I'll accept your plea of true and ask what evidence the state has.
State offers its State Exhibit 1 and its attachment into evidence.
No objection.
Without objection, the state's Exhibit 1 and its attachment are admitted into evidence. Do both sides rest and close?
State does.
Defense does.
Okay, I'll find there is enough evidence to substantiate the fact that the defendant has violated the terms of his probation. And I also find that a change needs to be made in the disposition of this case. Are both sides ready for that hearing?
Yes, Your Honor.
Yes, Your Honor.
Okay, I don't know that we need to waive it for a misdemeanor, but is there a waiver of a pre-sentence investigation?
Yes, Your Honor, we'll waive it.
All right, what is the plea bargain in this case?
Your Honor, we've agreed to that the defendant be sentenced to 30 days confinement at the Atascosa County Jail. Credit for 2 days that he's already previously served. And that's it.
Okay. All right, so you heard what was read into the record by the state's attorney. Is that your agreement with the state?
Yes, Your Honor.
Did the state's attorney add anything or leave anything out?
No, Your Honor.
Okay. Anything else on either side?
No, Your Honor. That judgment has been sent to the district clerk for the court signature.
And from the defense, Your Honor, the only thing I would like to add is that Mr. Lugo does have some medication that he will have to take while he's in custody. I don't know that anything can be done about that right now, but I trust that the jail can help him with that. And additionally, oh, sorry, Mr. Lugo?
I brought it with me.
Okay, very good. And then additionally, he has a broken ankle, and he has paperwork for that if the court requires it or if the jail requires it.
Okay, that'll be the jailer's call. All right, and Mr. Lugo, do you have a sufficient supply of your medication for up to 28 days?
Yes, Your Honor, I should.
Okay. All right then, and has someone gotten a copy of just the thumbprint page to the probation office or to the bailiffs there?
If Miss Ariana could email me the judgment, and I'll make a copy for the bailiffs.
Thank you.
We'll do that.
All right, then I will follow the plea bargain agreement in this case. You've previously been found guilty of assault causing bodily injury, a Class A misdemeanor. I will revoke your probation and sentence you to 30 days confinement in the Atascosa County Jail. Is there any legal reason why sentence should not now be imposed? All right, hearing none, it is the order, judgment, and decree of the court that you be taken by the sheriff of Atascosa County and confined for a period of 30 days. Your sentence will commence today. It will run concurrently with any other sentence or sentences you may be under, and you will receive credit for all of the time you have spent so far in jail on this charge. You understand, sir, that because I have followed the plea bargain agreement, you have waived the right to appeal and you may not appeal?
Yes, Your Honor.
All right, I will find that you made your post-trial rights knowingly, intelligently, and voluntarily, and I will approve them. And I will certify to the Court of Appeals that you have waived the right to appeal as part of a plea bargain and you have no right to appeal. I wish you good luck, sir.
Thank you.
And Ms. Biggs, I think I'm still waiting on a thumbprint on the plea I did this morning.
Oh, okay. Which plea? Oh, so you need a judgment is what the court's asking?
I have the judgment, but I was going to try to match the thumbprint up because that way I can do it electronically. And I know that way we have a readable judgment. If I can't do that, I'll just send it without the thumbprint.
Okay, so what the court is, I want to be, you are looking for the sheet, Your Honor.
I just want a copy of the sheet with a thumbprint.
Gotcha.
Judge, usually we get it signed by you and then we send them over there to get the thumbprints. But because you requested it now, I got the bailiffs to take a copy of the judgment and get a thumbprint. So as soon as I get it back, which I just got it just now. So let me give it to you right now.
Okay.
And Judge, may I be excused?
Yes, sir.
Thank you, Your Honor. Y'all have a good day.
Thank you. Do you need anything else from me, Your Honor?
No, somebody is going to post the judgment to me.
Yes, it sounds like it.
Okay.
Chris has everything, and I've sent it to Lada for the thumbprint.
Okay, excellent. Okay, I just posted the plea package to Miss Chris.
They're getting the thumbprint right now, Your Honor.
Thank you. All right, and is somebody calling the Eric Gomez NISI?
State is asking for that his bond be forfeited.
Hey.
KPS be issued.
All right. Can you call Eric Michael Gomez outside so you can sign the
Oh, that's right.
Can you call Eric Michael Gomez outside?
Yes, sir, I will.
Thanks. All right. So let's see.
Your Honor, there was no response.
Thank you. And did you get the, Chris, did you get the Olivant plea package back from me?
Let me check, Judge.
I'm not sure if I sent that. The reason I'm trying to do it this way around is when I can, on final judgments in civil and criminal cases, I'm trying to put a digitally verified signature on there. And if you go back later, you can go back and cut and paste it together with the thumbprint, but that invalidates the signature.
No, sir, I didn't get one.
Okay, I will send that to you right now. Okay, is that it?
I think that's it.
Did you get the thumbprint I sent you for Olivan?
I did. I'm just about to try and get to. County documents, Atascosa County. We'll move on, plea agreement. We'll move on, judgment. All right, so I will excuse everyone, I guess, except Chris. And my name is Tristan. I'll just wait for the thumbprint and the judgment on Mr. Lugo. And I need to call an officer back on a search warrant. But I'll,
Judge Lori did ask me on one of them on Bravo to bring that one up on page 5,
okay, what about it?
that there was no reset date given.
That's the one that the last thing that I had on there, Judge, was a bench warrant.
Mm-hmm. That's what she said.
Okay. Okay, what this is it already has dates, doesn't it?
Let me check. I'm just going off what Lori was telling me.
Okay, it was set for a bond reduction hearing, but he made bond on Friday, and Brad said he didn't want to try to, revoke his bond for not showing up for his bond reduction hearing when he's already made bond.
Actually, that was not him, Judge. That was the Garcia, Megan Harkins.
Okay.
This guy, we just got a return on it where they went to go and get him from Bear County.
Okay.
And he is no longer being held there. He was released from Bear County.
Okay, well then let's just, I'm going to take the remain on docket off, and let's pick a date where we give them a few weeks and send them a notice.
Can we do 7/26? We're pretty full up until that date.
Any objection from the state?
No.
All
No
right, so I'll
objection.
put clerk's letter 7/26.
Thanks, sir.
Excellent. Okay, I'll just wait on the other judgment and the thumbprint.
Judge, do you just want me to take you the judgment with the thumbprint on Lugo?
No, just email me the judgment and then scan the thumbprint in, and please email.
Okay.
But if you got an electronic copy of it, that way it's all readable and scannable. I'm trying to get our records so that 100 years from now, people can read them easily because they'll all be scannable.
For the Atascosa County archivists.
Yes. It's been years, but back when I was in high school, the first legal stuff I ever did was in the district clerk records in Floresville, Karnes City, and Pleasanton or Jordanton, researching a title. And there's some people that you go back and you just can see the signature of the notary, and you know which attorney drafted it, and you think, okay, this was done right. And there's some you go back, it's like, oh God, this is going to be screwed up, and it is. So I just, to the extent that it's a lot more trouble, I would like to leave the records in a way that they're easy to research.
Very well.
All right, so I'm going to mute this so I can call the officer. I'll be available though. See you in Floresville, Lachey. Okay, I'm back.
Judge, did your civil hearing fall through? Gloria just told me you had a 1:30 civil hearing.
No, I had it. Hold on a second. It's taking care of.
Okay, that's all I need to know. She just told me that and didn't tell me anything else.
All right, I'm sorry. That was my wife on the phone. All right, Ms. Tristan,
Yes, Judge.
can you send me the email or whatever copy you got from the email on this Lugo judgment?
I did email it to you.
I understand, but
Oh.
what I want to do is I want to take, not the scanned, the only thing I want scanned is the thumbprint.
The thumbprint only.
And
Okay.
actually, the thumbprint's not legible, so. Oh, I'm sorry, you sent me two things. I only got one.
I sent it to you on chat and then I emailed it to you.
Oh, I got it in the email. I'm sorry. Okay, yes. All right, yes, Ms. Starling.
Good afternoon, Judge. I just wanted to follow up and make sure you received an email I sent from a Karnes County case. I had
Yes, I
CC'd.
did.
Okay.
I'll try and sign that today.
Yeah, and it's not agreed. I put that in the email. I was just giving the additional information you requested and then my proposal. But I just want to make sure you received it.
Yes, I did get it. And I glanced at it. I need to take off and I'll be available a bit later this afternoon, but I need to take off because I have to go pick up my special needs son and get him to the house. And then I'll be available a little later this afternoon.
Yes, of course, Judge. Thank you so much.
Okay.
And Your Honor, I'm still waiting to hear back from Brian Powers regarding that Cirilo Cedillo. But as soon as I get his signed order, I'll get it e-filed and sent to you for your signature.
Okay.
Okay.
And can you actually, if you would email the Lugo judgment to me, I'd appreciate it. I asked for a different thumbprint because there's some, I don't think this one that we got is quite good. And I will
Okay.
match those up, but I need to go pick my son Rusty up at his camp and take him home.
I will email it to you, Your Honor.
Judge, and I don't mean to interrupt, but the Mark Olivan plea that you sent me is not signed by you. I was just looking at it to file stamp it, but
Okay, all right. Okay, please send me an email to remind me of that. I told my wife
Absolutely.
that I could be in San Antonio by 3 o'clock and I need to leave right now.
Okay.
Okay, so I'll get that done. And it'll be probably 4 o'clock before I get back to Floresville with my son. So I am going to leave the meeting and I will see y'all then. Or I will sign whatever I need to sign by starting about 4 o'clock.
okay.
Does anyone else still need this meeting open? Okay, I'm gonna close the meeting out. Have a good afternoon.